Hey guys, it's Joel Williams with Williams Elleby, a personal injury and wrongful death law firm in the state of Georgia. Today I want to take a minute to talk to you about a type of case we handle called trip and fall or slip and fall cases. These type of cases commonly happen at commercial establishments and businesses. Sometimes it's because of wet floors, sometimes it's because of things that people could trip over, sometimes it may be related to defective stairs or improperly marked curbing, whatever, but there can be hazards on the floor that would cause you to fall. Now, if you happen to fall over one of these hazards, it's extremely important to act fast and hire an attorney. Now, why is it important to act so fast? The most important reason that you need to act fast is that the attorney needs to send letters of representation to the property owner or management company, whatever it happens to be, and demand that the property owner or management company preserve any video footage, incident reports, maybe the hazard, anything that might be crucial to winning your case. You have to do this fast because if you don't act quickly, then some of that evidence may be destroyed forever and you'll never have it and not be able to pursue your case. Now, with trip and fall cases or slip and fall cases, there are certain things that you have to prove. They fall into a category called premises liability cases. In premises liability cases, you have to prove, number one, that the property owner or manager had knowledge that there was a hazard on their property. Now, that knowledge can be actual or constructive. Actual knowledge would be a situation where, say, I went to Walmart and I slipped and fell on a banana peel, but a Walmart employee knew that that banana peel was on the floor prior to me falling on it and just didn't clean it up. That's actual knowledge. Constructive knowledge would be a situation where, say, we have the banana peel on the floor, it's been there for 2 hours, nobody's noticed it. Well, Georgia law will imply under constructive knowledge that the business owner or manager, if they had a reasonable inspection procedure in place, should have found that banana peel and cleaned it up. In other situations, if there's an employee working in the immediate vicinity of the banana peel, then it may be that they have constructive knowledge of the hazard. Now, the next thing you have to prove is that the owner or management company's knowledge was greater than your own. This makes sense because if you know there's a hazard and you step on it or fall on it, that's on you. It's not on the property owner. So you have to prove that the property owner or manager's knowledge of the hazard was superior to your own. Then you have to prove that this event or this fall caused the injuries that you're claiming. So sometimes maybe you have arthritis or pre-existing conditions. That's okay because the injury can exacerbate those problems, or maybe it's a completely new injury. But in either event, you have to prove that that event or the fall caused your injuries. And then you have to prove the amount of your damages, okay? So at Williams Elleby, we handle these cases all the time. We're very familiar with Georgia law as it applies to slip and fall cases. The most important thing that you need to know is that we offer free consultations for those cases, and the sooner you hire us after a fall, the better. The sooner we can get to work for you, the better. You can contact us by calling at 833-LEGAL-GA, or you can visit us on the web at gatrialattorney.com. On our website, we have online chat where you can chat with us live, or you can fill out an online contact form and set up that initial free consultation. So call, chat, fill out the online form, get in touch with us and let us know when you'd like to meet so we can see if we can help you today.